Thank you.
SJC-11369, Commonwealth versus Galvin.
All right, let's proceed.
Good morning. May it please the court. My name is David Clayton. I'm an assistant district attorney in Middlesex, and I was the trial prosecutor in this matter. The trial judge in this case erred in retroactively applying the sentencing amendments of the Crime Bill of 2012 to this defendant. And I'd suggest to the court that that conclusion is required under both the non-repealer statute and also under Dotson. There's no language in the legislation which requires retroactivity of Section 14 of the legislation, which changed the sentencing provisions for this statute for this defendant.
Can I just ask you to clarify something I'm not clear about? Under Section 48, does that affect the eligibility for release of people who are, currently incarcerated, meaning that if they had been sentenced to 5 years for the same crime, but it's now 3.5 years, that they would be ready to go because the sentencing would go backwards as to them?
I think that there's a distinction to be drawn.
Is that right? Am I right about that?
While this information is not in the record before the court, it's my understanding from the Department of Correction, from EOPS, that they are allowing individuals who are serving sentences to appear before the parole board at 3.5 years as opposed to 5 years, even if their sentence was a 5-year sentence.
So there's a difference, though, between parole and release, right?
Correct.
I mean, they will not have been regarded as having wrapped up? That's not what the statute, that's not what Section 48 provides? It doesn't provide for them to just...
That's not what Section 48 provides.
Okay.
And I'd suggest that there's a distinction between the imposition of the sentence and the execution of the sentence. And I'd suggest that what Section 48 provides for has to do with the execution of the sentence as opposed to the imposition of the sentence. The imposition of the sentence is done by the trial court. And before August 2nd, 2012, the trial court was statutorily required to impose a sentence of not less than 5 years. Now, Section 48, for individuals who had already been convicted and were serving sentences, then I'd suggest changed the way the Department of Correction executes that sentence.
Doesn't that tell you something about the intent of the legislature generally?
I'd suggest that it does to some degree reflect the intent of the legislature, but it still doesn't change the underlying sentence. So the sentence is still a 5 to 5 in a day. The trial court has not changed the sentence for those individuals who have already been sentenced. It's still a 5 to 5 in a day. They're now able to appear before the parole board at 3.5 as opposed to the 5. It doesn't mean that they're going to be released, and that also.
No, but if they got a not a 5 to 5 in a day, but a 5 to 8, they could. Under the old version of the statute, they could not go before the parole board before 5, right?
Correct.
So there is that difference. But I meant more generally. Doesn't it tell you something about the legislative intent, and doesn't that tie into Chapter 4, Section 6?
Under the prior case law of Dotson and Section 4, Chapter 4, Section 6, there has to be clear, unequivocal language. And absent that clear, unequivocal language, then the statutes are not retroactive. And in this case, the legislature has not adopted or did not put any clear, unequivocal language into the legislation to make the sentencing retroactive.
If I can just, let's imagine we have two individuals. The defendant commits the crime on June 2nd, 2011. Let's imagine another fellow, we'll call him Harry, commits the very same crime. Same date. Harry is put in a fast track, found guilty, sentenced to the mandatory minimum before August 2nd, and is incarcerated on August 7th with a 5-year mandatory. He's eligible for parole after 3.5. Correct?
Based upon my understanding of how the DOC is implementing Section 48,
Well, he
yes.
potentially could be paroled to 3.5 years.
Correct.
Okay, this defendant, if you are right, cannot be paroled until, well, he has to do 5 years. He has no possibility of being released before the 5 years.
That is our argument, yes.
And your view is the legislature intended that those two persons be treated differently in that regard?
Again, I would suggest that, well, taking a step back at Section 48 again, I would suggest that that does have to do with the execution of the sentence as opposed to the imposition of the sentence. So really that's a question for the DOC to answer at a later date.
So we should just say, that's fine, just let the, I mean, it seems totally irrational, among other things, doesn't it?
The Section 48, again, it applies to the execution as opposed to the imposition. So for somebody who's already serving a sentence, who received that 5 to 5 in a day sentence, or 7 to 9, or whatever their sentence is, that sentence hasn't changed. And what we're arguing is that the judge, in this case, was still bound to impose the 5-year sentence. Now, how that sentence is then executed and implemented by the DOC is another matter.
Well, Section 48 would not apply because it's only those persons incarcerated on the effective date of this act, not after the effective date.
That is our argument.
That's what Section 48. Section 48 would not apply to this individual because he's incarcerated after the effective date. He could not enjoy an earlier parole date, correct?
Correct.
And why would they do that?
I'm not totally sure. In terms of the second question that was reported as well, as to the vehicle that is the proper vehicle for the Commonwealth to challenge what the Commonwealth believes is an illegal sentence. The Commonwealth does argue that 211.3 is the proper route, as opposed to a direct appeal under 278.28e. There is no provision within 278.28e that allows for a Commonwealth's direct appeal of these types of adverse findings. So the Commonwealth does argue that 211.3 is the proper avenue of appeal. And if there are no further questions, I would rest on my brief.
Thank you.
Good morning, Your Honors. May it please the Court. Attorney David Levington, on behalf of the appellee, Thomas Galvin. I was also trial counsel on this particular case. The Commonwealth's argument is really relying on the prior cases before this Court of Nassar and Dotson. Very similar issues where you're looking at whether or not a newly enacted or amended statute applies retroactively for a person that is awaiting trial. And I would suggest that this particular case is in line with those, but the questions that this Court raised in Dotson, whether or not the amendment intended to apply retroactively, I think in this particular case you have that missing information that was not apparent in Dotson. Section 48 clearly has retroactive language. It states that for those that are currently serving a sentence, whether or not we're looking at the execution or how it's implemented by the DOC, that particular person is then eligible for parole after serving the new mandatory minimum. You also have Section 14 under this new crime bill, which relates to the particular charge in this particular case, General Law 94C, Section 32A, subsection D, which states that for all persons charged after this effective date are subject to a new mandatory minimum of 3.5 years. I would argue to this Court that it would defy common logical sense that the legislature intended for Mr. Galvin in this particular situation to actually face a harsher penalty than those that are charged with crimes after this effective date, or for those that are serving a sentence and now get the benefit of being parole eligible. The example that Justice Gantz gave regarding Harry and the other individual really puts a situation to where you have three classes of people. Mr. Galvin being in the middle, probably the smallest class that's affected. And this particular issue with this crime bill is probably the most time sensitive because he was awaiting trial while this bill was passed. And after trial, as the trial counsel, I asked the Court to apply this newly enacted law, in reading Section 48, which clearly has retroactive language. I think this court in Dotson, in reviewing the oral arguments, that was the missing piece in the decision. What was the intent of the legislature? The legislature put Section 48 in there with retroactive language. Now, they could have included Mr. Galvin's situation in Section 48, but they didn't. So I would argue that Section 14 really controls the situation. He is included basically in the same situation as those that are charged with an offense after this particular effective date.
But are you saying 48 on its face applies to him?
Not on its face. However, the fact that the legislature did not include it in that particular statute, you can infer that as part of Section 14 that he's supposed to get the same benefit as those that are charged after the effective date. It wouldn't make sense that the legislature would leave him out of it. So those that are already sentenced after serving the new mandatory minimum, they are parole eligible. Everyone else is then given the benefit of the new 3.5-year mandatory minimum. It wouldn't make sense that if you accept the Commonwealth's position that Mr. Galvin could still be sentenced to a mandatory minimum of 5 years. So because his case is still outstanding, he suffers the worst. And that which brings up my third and fourth arguments regarding equal protection violations.
What was the sentence that Judge Fahey imposed? I forget.
She imposed a 3.5 to 3.5 in 1 day, and then 2.5 years in the House of Correction on and after for the park violation.
But even if you read it the way the Commonwealth suggests that we read it, he still gets some benefits. I mean, just the good time credits, work credits. He could get out before the minimum mandatory.
I don't believe so. He has to serve that 5 years, whereas someone that's already serving a sentence automatically has the eligibility for parole, work release after 3.5. He would be subject to a 5-year mandatory minimum.
He would, the Commonwealth's reading is that it's just as though there was no 2012 crime bill, period.
Correct. Right. So then anyone that's charged after him automatically faces a lesser sentence.
But he's eligible for things that he otherwise would not have been eligible for if the law had not been changed.
I think the Commonwealth's position is that he's not eligible for anything that's covered in this particular crime bill. So even though Section 48 doesn't explicitly mention his situation, I think when you read 48 and 14 together in the intent of this particular statute, Mr. Galvin is in the same situation as anyone that's charged with a crime afterwards.
That language, incarcerated on the effective date of this act.
Correct.
Incarcerated. He's not incarcerated.
He's not incarcerated, so essentially he's, I guess, considered a lame duck. He's that middle group of people that aren't sentenced and that haven't been charged. So theoretically, the judge could still sentence him to 5 years, just as a situation where this person, Harry.
Wouldn't it apply to, I mean, wouldn't the same argument be if he hadn't been tried before the effective date? In other words, charged before, but not, that would be the same place as
Right, that's the situation that my client was in. And for whatever reasons, whether a person defaults, that wasn't the case. In my situation, we just had delays in trial, and the act passed beforehand.
So he, by your reading and Judge Fahey's sentence, he does better than the person subject to 48 in the sense that his sentence is 3.5 to 3.5 in a day, which a person currently serving a 5-year sentence may be eligible for parole, but may not make
Correct.
it. Right.
He would do better. But I think that if the legislature wanted him to be under Section 48, they would have included that.
Right.
And that's why I bring up in my third and fourth arguments the equal protection violations. Here you, essentially with this amendment, you're creating three classes of people, and Mr. Galvin is basically unfairly treated. And I don't appear that there's any state interest that, a legitimate state interest that would say that that's what the legislator intended. And if there are no further questions, I would rest on my brief.
Thank you.
Thank you, Your Honor.